How do you become aware of an approved list in the course of settling a case? You're usually not going to hear about it at the mediation or at the time of settlement, unless you press the casualty company for that information. So when does it become exposed? It becomes exposed when you come to someone like me and you say, Jack, we've settled this case, and as part of the negotiation, the defendant has their own structured settlement broker, and even though you're the settlement planner for our client, it was agreed at mediation that we would have our expert work with their expert, and we need you to talk to the other side's expert. And my response is, fine, I'll do that. Were there any other conditions presented at the time of settlement with regard to this particular issue? No, there weren't. So I will go ahead and call, or the defense broker will call me, and I'll ask him for some disclosures. I ask him if there's a rebate or a kickback arrangement, contractual, between his company, his company, or any affiliate to the casualty company or any affiliate or agent of same. So I want that disclosure so I can disclose it back to you and your client. I also want to ask if there's an approved list. Are we limited in our choices out there? If our client decides that they want to take advantage of a structured settlement annuity as part of their settlement plan, are we limited in the companies that we can go out and solicit bids from on behalf of our client? And part of our process is not only to solicit those bids, but to try to work the market and these companies so that we get the best possible deal for the client with the highest rated companies, work them against each other and have them engage in a bidding process for the business. That's part of what we do here. So we want to know, is there a limitation? And it's amazing to me that at the mediation, the attorney is told that it's as simple as having me, the plaintiff's settlement planning expert, work with the defendant's structured settlement broker. But then I talk to the defense's structured settlement broker, and then the real truth comes out. There may be a rebate, although that's those are starting to become less and less frequent that we actually run into that. They're largely going by the wayside, and that's a good thing. But it's still an important question that we need to ask. But more importantly, and what we run into still are these approved lists. And I would maintain that if the defendant didn't reveal the existence of a limited approved list of annuity issuers that the claimant could access if they desired a structured settlement, that's a material condition of settlement. And that to reveal it afterwards is tantamount to reopening the negotiations on your case. I mean, if you'd have known that there was going to be a limitation, perhaps since that was a condition they wanted to place on the settlement, the plaintiff would have asked for something in exchange. Good example, more money. Since the claimant's choices are being limited, maybe that's worth more money in the settlement, and they should have gotten more money. But if it happens, if the disclosure happens after the mediation and after the settlement has been essentially agreed to, then the claimant has been denied the opportunity to ask for more money. And many plaintiff attorneys believe that is an attempt to reopen the negotiations, and they flatly suggest to the defendants that isn't going to happen. The negotiations are final, there will be no limitation. And of course then what ensues is disagreement, argument, sometimes even litigation over the issue. The way around all of this is pretty simple. One, it's to get these disclosures at the time of settlement. How do we do that? Well, we maintain that your best strategy always is to negotiate on the basis of the dollar amount that will settle the case. And that's the way plaintiff attorneys have negotiated cases for years. That's the way they like to negotiate them. But at that final offer from the defendants, before you accept it, that is when you want to turn the acceptance into a vehicle for getting all of your conditions and your client's conditions on the table, and hopefully getting the defendants to come up with their conditions also at the same time. So that case should be, or that final offer should be accepted in a format that says, and this should be in writing, by the way, I think in a mediation memorandum or a settlement statement or something, or even a letter. But it's best if it happens right there at the mediation and everybody signs on to it. It should say something to the effect that plaintiff agrees to settle for a combination of cash plus future periodic payments, comma, if any, comma, details to follow within 14 days or 30 days or some other arbitrary number, all of which will cost the defendants X dollars, the agreed upon settlement amount. Further, that statement should say that the plaintiff has their own structured settlement or settlement planner, and that will be the settlement planner, the individual that represents the plaintiff, and the only individual that represents the plaintiff, that there will be no limitation in companies that the claimant can access for bids on their package if they should decide they need a structure, and if they should decide they need a structure, that the defendant, casualty company, agrees to execute any and all documents to effectuate that settlement. In addition, we've suggested a couple other conditions on there, including one that says that if the claimant dies before the settlement agreement is executed, that the settlement is final and that the defendants aren't going to dispute it and they're going to pay the money anyway. We call that a stipulation of settlement clause work. We've got it here in digital format and can email it to you if you'd like to see that. Contact me at my office. My email address is at the bottom of this page on this e-zine that you've gotten. Be happy to supply it to you and help you with it. It's a great strategy. It's a great way to get all this stuff out in the open so that it can be negotiated at the time of settlement and not become an obstacle to settlement later.